If you have a child support order and you get sentenced to prison or even some county time, like 6 months or 364 days, you can't just trust that the state or the other party in your case is going to somehow just automatically adjust the child support numbers at some point in the future. The state, the other side of your case, the other party, they're not going to do you any favors at all. But in this video, I'm going to tell you exactly what you need to do if you have a child support order and you go away for a while. All right, guys, as always, nothing in this video is meant to constitute legal advice or is an invitation to establish an attorney-client relationship. Though I'm licensed to practice law in Florida, I don't give anybody legal advice, so just keep that in mind. If you're outside of Florida, you want to always consult your own attorney in your jurisdiction regarding your specific set of facts. Okay, let me paint the picture. I'm on child support, I pay $500 a month, and I get sentenced to 3 years in prison, or 364 days in the county, or 6 months in the county, whatever, fill in the blank. My child support order does not automatically change, okay? At least where I am. It's not going to automatically change. If I go into prison or I get locked up, I'm down for a while, I have zero income. I have no ability whatsoever to earn income and pay my child support. So that is basically a substantial change in circumstances, right? I am now going to be in a situation where even though it was something that theoretically I did to get me there, my income has changed. What I don't want to have happen is I get out in 3 years and I owe a mountain of backdated delinquent child support that was cha-ching, cha-ching every month based on the calculation for child support that I got when I was working full-time, right? Because that wouldn't be fair. So what do? I would have to file the right paperwork with the court to seek a change in my child support obligation for the time that I was going to be away. Obviously, whenever anyone's going through any sort of situation where they're fighting some charges, the criminal case is going to be their number one priority. And they're not really going to be thinking about, hey, let me put fighting these charges on hold so I can figure out what to file with child support. Because a lot of times when you're fighting a criminal case, you don't even know that you're going to be going away or how long you're going to be going away until the very end of the case, when you either plea out or go to trial or what have you. In many cases, by the time dad figures out that he needs to try to do something about his child support, he's already incarcerated and very limited in terms of the resources that he has to file something with the court or submit something where it needs to be submitted. Prisons have law libraries, and there's like a inmate law library in there, and they may or may not know what to do or what to file. But at the end of the day, they're not attorneys. They're not formally trained in the law, and they can't give you legal advice. In my experience, what needs to be filed is a petition for modification. This is in cases where you don't have just an administrative order, but your order is being enforced by the actual circuit courts. That means that your child support case lives in a file in the courthouse. Now, I've made other videos on this channel explaining what the administrative process is in the states that have the administrative process, like where I'm at in Florida. That's a little different because if you have an administrative case, you can't file a modification with the courts. You have to first file a motion to basically take that administrative case from the state administrative building that's across the street from the courthouse and transfer it to the courthouse. So it is now a circuit court case with a circuit court case number. Once you have that, then you can file a petition for modification. The modification is pretty simple. You're alleging that there's been a change in your financial circumstances. You've been incarcerated. You've been sentenced to a certain number of years, and that you need a modification of your child support. File it. Have a process server or a sheriff serve the other party with it. In states like mine, the date of filing controls the date that your modification can take effect. So if I file on January 1st and it's not until June of the following year that I actually get a hearing on my case, if they do grant a modification, as long as I ask for retroactive relief in my petition, my modification can get awarded all the way backdated to January of prior year when I originally filed my petition. But if it took me until June 2 years later to file my petition, then I can't go all the way back to January. I can only go back as far as the date that I filed my petition for modification. If you're incarcerated and you've got limited resources there, obviously, because you're incarcerated, and you're trying to figure out how to do this, I think the first place to start is close, family members or close friends. See what sort of assistance they can get you. If they can hire you a child support attorney who understands how this stuff works, the attorney can really spearhead that process and get it done. Most people can't afford an attorney. And so they've got to feel their way through it, which makes it difficult because sometimes people will say, hey, I'm going to file a motion to modify my child support. And they file this motion and it just sits there and they think they're good. They think they're protected and they get out and they find out that they're not, because the courts aren't going to treat a motion to modify, at least like where I'm at in Florida. The court's not going to recognize a motion to modify the child support award. It's going to have to be a supplemental petition for modification, a formal petition that you file with the court. You pay a filing fee. You got to get a summons issued by the court. Process server or sheriff goes out and has to serve the other party. It's just like you're filing for divorce, almost same procedural process. If you're going through the courts, a little more streamlined if you're going like through the child support hearing officers, but the other party has to be served, and you can't serve the DOR. You have to serve the other party. A lot of jurisdictions, if a case had been sitting with no action for about a year or so, the court itself will move to dismiss the case based on lack of action. So your strategy should never be to just file it and then let it sit. The strategy must always include a plan for moving that case forward. Luckily, since the pandemic, everything everywhere is equipped with Zoom capabilities. I venture a guess to say that all courtrooms, even child support hearing officer courts, are going to be set up to use Zoom for virtual attendance. And you can absolutely appear that way from the county jail or from a state penitentiary. So definitely got to have a plan. Be careful also, because when you're dealing with these Title IV-D, Department of Revenue, state child support cases, a lot of times your family members or your close friends will call the Department of Revenue, their customer service number, for you and say, hey, I need to get a modification filed on my cousin's behalf or on my brother's behalf. And the person on the other end of the phone is going to say, oh yeah, no problem. What's their name? Okay, we're submitting a modification right now on his behalf. You're good to go, right? They'll say that, wrong. They're not submitting a true modification. They are putting in a non-official request for a support order review. And that is, it gets put in a queue, and then somebody, I don't know if they know what they're doing or if they're paid enough or trained enough or whatever, is going to look at the person's file, and they're going to take just a quick cursory look at it and just say, yeah, it looks like this person would qualify for a modification. Or they'll say, no, I don't really see any qualifications here, so we're just going to deny it. And maybe they get notice of our denial and maybe they don't. In my experience, the vast majority of those requests are denied. If it's by dad, the respondent, the vast majority of them are denied. And in the vast majority of cases, dad never receives the notice that it was denied in the first place. And that is not a modification that is going to hold your date for modification. This is important information because there's a lot of people in prison. There's a lot of people who pay child support who are in prison. There's a ton of people who are going to go to prison. There are a ton of people who have been to prison. Nobody out there is talking about this. And so you're going to have all of these guys and girls getting out of prison, getting out of jail, and realizing that they owe all this money from when they were locked up. So share this video with a friend, share it on all your social media accounts, hit that thumbs up icon. That really helps us out in the YouTube algorithm. Don't forget, let me know in the comments below if there are any video topics that you would like to see, and I'll catch you guys in the next one.